So let's begin. Today we're continuing our discussion of Indigenous child welfare, and today we're going to be focusing on the governance aspects of this issue, some of the successes, some of the challenges that are part of that development. We have 4 more classes left today, plus 3 more dealing with criminal law. And as you prepare for the exam, keep in mind the kind of the division of the course, where we've been looking at those issues that seem to be more externally focused, Section 35, title, treaties, consultation, federalism, and then those issues that seem to be more internally focused, which is what we've been dealing with over the past few weeks here. And I'll talk more about the exam as we go on. So you have a slide here to begin that talks about or identifies for you the gaps in Indigenous and non-Indigenous access to resources. So what you see here is some information about child poverty in Canada. And you'll notice that Indigenous peoples often have 2 to 3 times the impoverishment of the general population. So for instance, in Saskatchewan, there's about 16% of the population of non-Aboriginal peoples that their children are in poverty, whereas in Saskatchewan, it's 55% of the peoples that would face poverty as Indigenous people. Likewise, 15% of kids in Ontario are in poverty, 34% of Indigenous kids are in poverty. Here in British Columbia, 17% of children generally, which is too high a number right to begin with that number, non-Aboriginal kids in poverty, about 39% of Indigenous kids in the province of British Columbia grow up in poverty. So when we talk about governance issues, when we talk about how the courts and legislatures are approaching this, we need to remember kind of those bottom lines, which is seeking for ways to improve the life of children generally, and then Indigenous children in particular. So the way we're going to go through the materials today is by starting with a very wide frame and then coming down into more specificity. We're going to talk about the international instruments and the way that the global community has identified for Indigenous peoples and children more generally standards that could be set to guide our cases, our policy, our legislative responses from both the United Nations Declarations on the Rights of Indigenous Peoples and the Convention on the Rights of the Child. Following that international discussion, we then will talk about whether or not looking after children could be considered integral to distinctive culture prior to the arrival of Europeans, or whether or not governance in relationship to children could be protected as an Aboriginal or a treaty right under our Constitution as Canadians. So that's the second part. The third part will then be the federal government's role in acting under Section 9124 of the Constitution Act 1867, Indians and lands reserved for Indians. And we're going to ask ourselves, why has the federal government not occupied the field in that regard? Why has it left this area broadly to the provinces? And then we'll look at some examples under the Indian Act as to how First Nations might pick up control of this issue through the Spallumcheen banned case and the Spallumcheen bylaw. So we've got international, federal, international, constitutional, federal, banned, and then we'll look at the provincial jurisdiction and how the law in the province has attempted to delegate authority to Indigenous-specific agencies to deal with Indigenous child welfare. Following that discussion, we'll look at the Provincial Child and Youth Representative and the work that that office does to try to hold to account what's going on in the province in acting under provincial jurisdiction. And then the Auditor General's remarks. And then the following 2 issues, the last issues that we'll talk about today, have to do with challenges of Aboriginal control. We'll look at the Desjarlais case in the materials, the Jane Doe case in the materials, and then finally the Casimel case, which recognizes that it's possible that custom could be considered a part of Canadian law and could be given force through, in this case, an insurance statute. So that's the overview of where we're going today. Very general, international, constitutional, federal, band, provincial, and then looking at First Nations' own initiatives and some of the challenges that are part of those initiatives. So we begin with the international regime, the Declaration on the Rights of Indigenous Peoples. And as you know, all countries in the world have now signed on to this declaration. There were 4 holdouts, as I mentioned before, when this was first approved in the world community. Those holdouts were Australia, New Zealand, the United States, and Canada. They did not want to accept this regime originally, although after 2007, there was further acts to eventually bring them on board. And here you see different articles that would touch on issues dealing with Indigenous children that could be taken by the federal government, could be taken by provincial government, could be taken by First Nations, Inuit, and Métis governments to try to act in accordance with this way of identifying standards. So, for instance, Article 7, after talking about rights to life, physical, mental integrity, liberty, and security of the persons, say Indigenous peoples have a collective right to live in freedom with all of these certain ways, including right to avoid the forcible removal of children from the group to another group. So, international standard to avoid forcible removal after that pattern. That I think would cover any kind of residential school setting if that was to be developed in the present day. You wonder to what extent child welfare regimes actually might fall afoul of this provision to the extent there's a forcible element where the collective itself does not have a say or a role in the way their children are being taken from them. Article 8, Indigenous peoples and individuals have the right not to be subjected to forced assimilation or the destruction of their culture. Again, could be talking about child welfare in this instance, if it is the case that these regimes work towards assimilation, which it seems like they do in some respects. States shall provide effective mechanisms for the prevention and redress for any form of forced assimilation or integration. Article 9, Indigenous peoples and individuals have the right to belong to an Indigenous community or nation in accordance with the traditions and customs of the community or the nation concerned. Article 14, Indigenous individuals, particularly children, have the right to all levels and forms of education of the state without discrimination. We learned last class that Aboriginal peoples on reserve, Aboriginal children on reserve, receive 22% less in funding than non-Aboriginal children, so we might have a problem there. And then Article 22, particular attention shall be paid to the rights and special needs of Indigenous elders, women, youth, and children, and persons with disabilities. You might know that a lot of kids in care often have special needs. I can't remember the exact statistic, but I think it's over 50%. It's often fetal alcohol syndrome, the spectrum of the effects of when you're in the womb, in utero, and your mother drinks, and that is often passed on to the child, and it's difficult for that child to make judgments in the same kind of way because of that effect. There's also other issues that end up with children having special needs, and Indigenous kids in care, not all of them by any respect, but a good number of them have these special needs, and so this Article 22 says there needs to be provisions made for dealing with not only the special needs in relation to culture, but culture as it intersects with indigeneity. And then states shall ensure, in conjunction with Indigenous peoples, to ensure that women and children enjoy the full protection and guarantee against all forms of violence and discrimination. So a pretty heady, important, weighty statement of principles that is present in international forums. And you know, I think, that under the Trudeau government just elected, there was a platform promise to review all the legislation of the federal government to make it comply with the Declaration on the Rights of Indigenous Peoples. So to the extent that children, Indigenous children, might be in need of some of these protections, we can only hope that there might be legislative and policy responses at the federal level to be able to accord with these standards. You might also know the province of Alberta, when Rachel Notley's government came into power, also made a similar promise, and they are currently in the process of reviewing all their legislation to see whether or not it complies with the United Nations Declaration on the Rights of Indigenous Peoples. And as you know, Alberta has control over child welfare in the province. One would hope that these kinds of provisions here would get that implementation application. Questions or comments there? Yes.
Actually, you mentioned the 22% less funding statistic.
Yes.
What are the causes of that?
So the question is, why is it that Aboriginal children on reserve receive 20%, 22% less funding than children educated off of the reserve? And it's just a deficit of being able to bring this up to funding parity. We've been in a time of austerity in accordance with conservative government and liberal government before that, and so there's not the infrastructure. You have poor schools, overcrowded schools. Teachers are hard to keep on staff because they're not well paid comparing to teachers and the salaries that they would receive off of the reserve. The special needs functions in terms of helping kids with special needs are not as appropriately funded as well. There's just been a cap on funding, and this has not kept up with the kinds of funding that's happened in the provincial sphere. Which may be part of the hope that First Nations would get rid of going to schools on reserve and just integrate with the more general population. And so if the reserve schools are challenged, that creates an incentive for parents to send their kids off reserve, and for maybe communities themselves to shut down their own schools and just enter into contract agreements with the local school board. I'm not sure that that intent is all that prominent, but it's, you know, as I say it, you could see an incentive that certainly flows in that direction to just try to get kids away from relying on federal funding and put them into a provincial sphere. We also have the United Nations Convention on the Rights of the Child, which makes many of the same points. So even if we're not thinking about Indigenous, the Declaration on the Rights of Indigenous Peoples, which after all is only a declaration, it's not necessarily binding on the states. This is a convention. This is a treaty that Canada has signed that supposedly they should then apply through their own domestic sphere. And so you see, state parties shall respect the responsibilities, rights, and duties of parents, and where applicable, the members of the extended family or community as provided for by a local custom. And so the mention there of custom being an important part of child care, extended family circumstances. Article 2 talks about placement of children outside of their home, and when this placement occurs outside of their home, such care could include placement in suitable institutions for the care of children. When considering solutions, due regard should be paid to the desirability of continuity in a child's upbringing and to the child's ethnic, religious, cultural, and linguistic background. It's fair to say that all provinces have provisions in their legislation that says to frontline workers that due regard should be paid to Indigenous, Aboriginal, or Native heritage in the placement of children outside of their home. The question is the follow-through with that due regard. You can have it in legislation, which is good, but you need to have that applied. Article 30, in those states in which ethnic, religious, or linguistic minorities or persons of Indigenous origin exist, a child belonging to such a minority who is Indigenous shall not be denied the right in community with other members of his or her own group to enjoy his or her own culture, to profess and practice his or her own religion, and to use his or her own language. I'm going to talk much about language rights in this class, but I maybe have mentioned once or twice that there's only 2 Indigenous languages in Canada that are likely not threatened in terms of them being extirpated from the earth. That's the Algonquian languages of Cree and Ojibwe and the Inuit language. All the other languages, 50 of them, are in danger of going out of existence within the next decades, certainly within the next 100 years. Some of these communities only have 1 or 2 language speakers left. And to the extent that children can't be with parents, extended family, that aspect of language, religion, culture is something that is not able to be transmitted when we're in a crisis situation. So that's the UN Convention on the Rights of the Child, which makes general provisions and specific provisions for Indigenous peoples to be implemented by nation states. Questions or comments there? So that's the view from kind of 30,000 feet, looking as broadly as we can. Then we can take this more particularly into the domestic sphere under Section 35(1) of the Constitution Act, and can ask, is child welfare an existing Aboriginal and treaty right in Canada that should therefore be recognized and affirmed? The answer so far is that the court has not declared this to be true. The court has not declared that child welfare or making decisions in relationship to children is integral to the distinctive culture of peoples, therefore is recognized and affirmed, or it's part of a treaty process, but therefore is also recognized and affirmed. However, you could think of potentially supportive cases that in the future could be developed to show that there's a power, authority, a jurisdiction that Indigenous peoples have to take care of their kids. One of those cases is Conley and Woolrich. You might remember that case from the first day. This is a case of a marriage taking place on the prairies in accordance with Cree law. This marriage eventually breaks down as the male partner who's non-Aboriginal goes back to Quebec, takes up a relationship with a non-Aboriginal woman, but then he dies. And when he dies, there is 2 claims to his estate. The claim of the second marriage that took place in Quebec, but also the claim of the children of the first marriage that took place on the prairies in accordance with Cree law. And in deciding who had the rights to half of that estate, the court found that Cree law was a part of the law of Canada, such that when the marriage broke down, the children of that first marriage, in accordance with Cree law, had a claim to those monies that were residuary of the estate. In other words, Cree law is a part of the law of Canada. And this case occurred in the first year of our country in 1867, and was affirmed by the Quebec Court of Appeal. To the extent that that case shows that custom continues to survive and is a part of our constitutional order, this might give protection not just for the marriage relationship, but also for children as a part of the ongoing relationships of Aboriginal communities. Questions there? Then there's the Mitchell case, which we haven't spent a lot of time on, but again, it was in our first weeks of materials. The court, it's a 2001 case of the Supreme Court of Canada. The question was whether or not Indians could bring stuff back and forth across the border in accordance with the Jay Treaty, which is a treaty of 1794 that allowed Aboriginal peoples to have that kind of access, or in accordance with their Aboriginal right to trade. The court, in looking at this issue, whether or not there was an Aboriginal right to bring things across the border because of their historic trade, it was integral to their distinctive culture prior to the arrival of Europeans, was the claim. The court said there wasn't enough evidence there to be able to support that claim. However, in looking at this case, the court said that we presume that there's a continuity of Aboriginal rights. If there's not been an extinguishment clearly and plainly, say of a right to trade, then Aboriginal people still have it. You could say, if you draw by way of analogy from that statement, if there was a right to be able to raise children prior to the arrival of Europeans, and that's continued post the assertion of sovereignty and not been explicitly and clearly and plainly extinguished, therefore Aboriginal peoples would have that right today. And in fact, the Indian Act recognizes adoption and custom, so it may be that the Indian Act didn't extinguish that right to be able to raise children, although of course you would have lots of obstacles along the way, given what the residential school system has done in trying to erase a lot of Indian culture. There's an argument there. Yes. Yes.
Up to a few years ago, custom adoptions were still recognized because I did some, and I got the papers showing that the children were in my name.
Yeah. You can still do custom adoptions in British Columbia. You can still do them in most provinces. And this is a great example to show just recently that would be. So, here's adoption in accordance with custom that's recognized by British Columbia law. Therefore, why couldn't you say that this has survived under Section 35(1), therefore is recognized and affirmed? The Campbell case we looked at again at the beginning of the terms, a little bit of a review for you. There was an argument by the government that the Nisga'a Treaty was unconstitutional because there was a third order of government in the Nisga'a Treaty, because the Nisga'a people could make their own decisions around land and resources and taxation and tribal courts, etc. How the Nisga'a people also have the ability, under the Nisga'a Treaty, under that constitutionalized document, to make decisions about children. The Nisga'a have a treaty right to govern themselves in relationship to child welfare matters. The Campbell government, Gordon Campbell, when he was in opposition, actually, brought in a claim saying that this is unconstitutional because all legislative authority in Canada was divided between the federal government under Section 91 and the provincial government under Section 92, and therefore there was no constitutional space for any other order of government. In the Supreme Court of British Columbia, in the Campbell case, the court rejected that argument. They said that not all legislative jurisdiction is 91 and 92, or federal and provincial. In fact, Indigenous jurisdiction survived the assertion of sovereignty, the creation of Canada, and in the Nisga'a Treaty it was modified, that is the Nisga'a jurisdiction, the Aboriginal right to govern themselves was modified and made into a treaty form of protection. So this case might one day be important for finding a Section 35(1) right to governance, but again, we don't have that declaration yet from the courts. The Vanderpeet case is the thing I've been talking about all along here. kind of seems just logical that it would be integral to the distinctive culture of any group of people to make decisions about custody and care and adoption and extended family relationships. However, when these cases have been raised, there's not been success. The courts have not been prepared to assume that Aboriginal peoples have this Section 35(1) authority. And the case here, Pikwakanagan, I'm just trying to find the exact page here. I'm on page 919. The court said there was no proper evidentiary basis established for being able to declare that bands had jurisdiction over their children. First, the court says, I find no evidence of any particular or even general child-rearing practices of the band or the First Nations in general. Yes, there's reports and studies about how Aboriginal peoples take care of their children, but these are not evidence, and they say nothing of the traditional rights the band seeks to protect. And then the court goes on to further say, in relationship to Anishinaabe and Wendat, understandings of their own child-rearing practices. Nowhere are any of these traditions or practices described. There's no evidence before me to conclude that the native child-rearing practices are unique. Now that's got to be a misunderstanding of Section 35(1), that you have to do something unique in order to be able to claim right under that provision. In fact, we saw in the Marshall and Bernard case that we read earlier in the semester that when the court says distinct, integral to distinctive culture, they don't mean that they're the only group in the world that's doing that thing. It means that it's important to them. It marks out their culture. It's what makes them who they are, not that they're the only group in the world doing it. But that, nevertheless, this case stands as one example. It's one of the frustrating things about this area, to say that you just can't assume a continuity.
So couldn't you challenge it on the basis of band? Because band isn't our terminology.
Okay. That's right. So this
So
idea...
It's a government.
Band is a government creation. You could say that the idea is that it's in a family setting, but maybe this is the problem. The government says you're bringing the wrong body forward to be able to claim this governance practice. It's not the band that has it. Like the Chilcotin, remember, it wasn't just the band that got the Declaration of Aboriginal Title, even though it was one band that started to initiate the case. It was the entire nation that was able to succeed in having a declaration of that title, the 6 bands together. So maybe this is an issue, not that we shouldn't be bringing this as bands, it should be brought as a nation. Then the second case here is R.T.R. from Saskatchewan Queen's Bench. There was an argument by the agency and the band that Aboriginal notions of community and kinship, I'm now on page 920, are integral to the an integral part of Aboriginal society, and that the Aboriginal right of self-government includes the obligation to speak for persons who are under a legal disability, including children, and that this has never been extinguished. The court, in receiving that argument, says there's no evidence before the court to establish the Aboriginal right claimed. There's only evidence of kinship. Kinship isn't enough in this instance to be able to pull forward that protection. So there you have it. Cases that are potentially supportive, but whenever it's raised, there's not been sufficient evidence to be able to substantiate the point, and the court is unwilling just to assume that that's what nations do, is look after their kids and make decisions about them, which would therefore then be part of Section 35(1). Now, when we think about these two cases and ask ourselves, why is it that we might not have this recognition beyond just the court's unwillingness to assume? I think it's because of the cost that's involved in making a Section 35(1) claim. You know, it costs $25 million to bring the Delegated case to establish Aboriginal title. It costs $40 million to bring the Spallumcheen case to establish Aboriginal title. Think of all the experts you have to marshal. Think of the political effort of bringing a nation together when they've got so many other issues and priorities. It just could be expense. It could be the political challenge of that that's standing in the way. Because it just would seem logically to at least assume that it was there, or they would have some evidence to claim it. Then the question is whether or not it's extinguished. That's a whole other matter. But just even that first starting point. Questions or comments there?
I was just thinking that in Tlingit culture, especially historically, the raising of a child belonged to the community. Aunts and uncles had as much a role in raising a child as the parents did. So, and that's distinct, that's unique.
Yeah, that is distinct and unique compared to some other cultures in Canada. Although there are family-oriented cultures that raise children in this extended kinship way. But you're right?
Yeah.
This is part of what just makes Tlingit who they are, to have that kind of a family structure. And the fact that that wouldn't be assumed, or we don't have evidence on it yet, is a huge challenge.
In the Haida culture or ways of doing things, it's very similar to Tlingit. We even have terminology that tells you which aunt and which uncle you would go to for specific things. They have, like the mother's sisters are called Auka or Aukalang, whereas the father's sisters are called Anga. And so you know for one set of things you go here, and for another set of things you go here.
Yeah. Which
So-
seems like a practice, a tradition that's integral to the Haida people prior to the arrival of Europeans, that has a continuity to today, which you would think would get this kind of protection. The Anishinaabe people have a similar kinship structure where the names linguistically are identified with responsibilities and care duties that might be there. The word for father in Anishinaabe is no-se. The word to walk is bimose. The word for motion is ose. So no-se, actually, here's the image that this indicates. It's someone, picture heavy snow, and I've got my snowshoes on, and I'm walking through the snow, and by plowing through that snow, I make it much easier for the people that follow me to be able to make their way through the world. Right, so a father is someone that tries to make it easier for their children to be able to walk through life. Ngusha is the word for mother. It's the idea of those who raise up the little ones around them. A little child is called Abinongies. Oji is actually our word for fly. Abinongi, but a fly is called that because a fly is those that hang around. Abinongies, the children, they just hang around. They're not actually able to go that far, and so they need that kind of care. So Abinongies, Abinongi for children, and then I could just go on and on. Each of these linguistic terms contain guidance about how you would think about, deal with, care for children in the context. And it's just so frustrating that here we are in 2015 and we don't have a recognition of our rights, constitutionally speaking, to be able to look after our little ones in this fashion. Questions? Okay. Is there a treaty argument to be able to claim rights to look after children? Well, remember the standard in the Marshall case is that a treaty is that which best reconciles the intentions of the parties. Problem is, in many treaties, they didn't often think about the kids. They were thinking about sharing land or sharing resources, and so you wouldn't have an intention necessarily found in the treaty to be able to say, you know, First Nations or community group, you have this opportunity, responsibility. So that's one thing, right? It just might not be there in the language and therefore you can't bring it out. Okay. Secondly, it may be the case that it is in the treaty. So for instance, in many of the numbered treaties, there's provisions dealing with education, that the federal government will have responsibility to provide schools, education for the community. And so there are arguments and cases about the treaty right to education. But that's more about, you know, government helping First Nations through resourcing to be able to deal with their own family issues. It doesn't actually look at the internal family dynamics. So you might not necessarily find rights to child welfare and governance through the treaty in that regard. I think the best argument is the Winans argument. Hopefully that word means something to you by now, which is treaties are a grant of rights from the Indians, not to the Indians. If the treaties don't give something, if the Indians don't give something to the federal government, then that remains vested in the tribe, in the First Nation. And so if you didn't talk about child rearing practices in a treaty negotiation, if that wasn't given to the federal government, it remains vested, or it's reserved. That power is reserved to Indians until such time as they decide otherwise.
Does that not fit in with the presumption of continued rights until they're explicitly extinguished?
That's right. Very much fits in with that Mitchell case, presuming that rights continue until they're extinguished. That thing that's not been given in treaty, therefore continues. Treaties aren't therefore an overarching umbrella extinguishment of everything you've ever had.
You know, just, I don't know how much like legal weight you sort of have going back to those wampum belts where you have two canoes going next to each other. And that would seem to indicate that, like, you know, like rearing your children is very much in your canoe.
Yes.
And that would seem to give the indication that they were viewing things like you know, things with the family, things like child rearing would definitely be in the First Nations would be doing that for their own society.
Perfect example, right? The wampum belts could be read in such a way that also in treaty terms recognizes within your canoe, in your river of life, controlling your own affairs, includes your family, your kinship arrangements. And that puts me in mind of other things like totems and whatnot that would also communicate family relations.
I'm just thinking the peace and friendship treaties in the maritime provinces have this phrase, the Indians will not be molested in hunting, fishing, planting, or other lawful occasions.
Okay.
Which is a phrase that's never been defined what those lawful occasions are.
Yes.
It could potentially be quite broad, but again, you run into the same type of problem.
It's a good addition though, right? Under the peace and friendship treaties in the maritime provinces, if Indians aren't to be molested in their lawful occasions, you would think perhaps what a lawful occasion is looking after your children. To the extent that federal or provincial law interferes with that, it's contrary to treaty and is a violation of treaty there.
I was just wondering if you, just talking about the Mitchell versus the Winans idea, do you think there's a distinction in the fact that extinguishment seems to be more of a unilateral extinguishment versus if you supposedly treaty something, it's a, you know, it's an agreement?
That's right. It depends on your view of treaties as to what survives after those negotiations are over. Sometimes you get the sense that treaties are combined with the doctrine of discovery. That is, Crown has the overarching rights here. We're going to enter into a relationship with you through treaties and negotiate a few things. But we're doing this as a government using the doctrine of discovery, which you know, would overwrite your rights. Whereas if you put the doctrine of discovery aside, you say this is about mutuality. And of course, the court has rejected terra nullius in the Chilcotin case. If you try to put that aside and say this is about mutuality, if the Indians don't give it up and there's no overarching Crown sovereignty to interfere with, infringe with your children, then that still remains within the First Nations to deal with. Yes.
Does the Nisga'a have child welfare authority in their treaty?
They do, the Nisga'a Child Welfare Authority Amendment Treaty, right, which recognizes that in the contemporary context, you also could put that into treaty. So that's, so we've done two things, international and then domestic. Now let's look at federal legislation. Why has the federal government not occupied the field of child welfare for Indians on their lands? You could have an analogy to Chilcotin. So here's paragraph 130 of the Chilcotin decision. First, the doctrine of paramountcy applies where there's a conflict or inconsistency between provincial and federal law, in the sense of impossibility of dual compliance or frustration of federal purpose. So not just application, but the purpose of the federal law. In the case of such conflict or inconsistency, the federal law prevails. Therefore, if the application of valid provincial legislation, such as the Child and Family Services Act, that is the Provincial Child and Family Services Act, conflicts with valid federal legislation enacted pursuant to Parliament's own power over Indians, as the federal government acted through a Aboriginal Child Welfare Act, the latter would trump the former. So a federal Indigenous or Aboriginal Child Welfare Act would trump the Provincial Child and Family Services Act if the federal purpose was to totally take up the field, not leave any room for the province in that regard. So that's just first-year constitutional law, thinking about paramountcy. So there's an example of this occurring to the south of us in the United States through the Indian Child Welfare Act. Tribes, as First Nations are called there, have exclusive jurisdiction over Indian children that are domiciled on the reservation. I'm actually teaching a course in May, an intensive course for the month of May, which will talk all the time about federal Indian law, and then we'll keep drawing analogies back to Canada. These tribes and states have concurrent jurisdiction over member children not domiciled on reservation. So on the res, tribes get it all. Off the res, if there's an Indian child, the state and tribe share the jurisdiction. However, in the case of foster placement or termination of parental rights, states must transfer the case to tribal court upon the petition of either parent, custodian, or tribe. So if there's a petition in this concurrent jurisdiction, it's a petition from the child or the custodian or the tribe, it has to go to the tribal court, to the tribal jurisdiction, unless the state finds good cause for retaining the case, or either parent objects to the transfer. By and large, this means that, if you're living in Maine as an Indian child, the state and tribe would have concurrent jurisdiction. If you're going through the transfer or placement, but say your tribe is the Navajo, so you're at that point, the Navajo could make application in the state of Maine to transfer that case back to Arizona, New Mexico, Colorado, or Utah. Because that's how far the jurisdiction of the tribe extends, right? It extends to the person there. It's not necessarily just a land-based sovereignty. It's a personal sovereignty. And states must enforce tribal custody decrees in state courts. So that child then comes back from Maine, the matter is dealt with in the Navajo court. The Maine court in Maine has to give force to that tribal court decision. There's a placement preference here, which is first for family, including extended family, then the tribe, and then finally other Indians. So this legislation is an example of paramountcy, of occupying the field, allowing tribes to have jurisdiction across the United States. Here's the preamble. Recognizing their special relationship between the United States and Indian tribes and their members, and the federal responsibility of Indian people, Congress finds a constitutional grounding for this authority, which for us would be Section 35, not the Indian Commerce Clause. Finds it in the treaties, finds the authority in the direct interest that the United States has as a trustee in protecting Indian children. So you could say maybe that if we had a piece of legislation in Canada, we talked about the honor of the Crown, or the fiduciary responsibility that might be present. That an alarmingly high percentage of Indian families are broken up by the removal, often unwarranted, of their children by non-tribal public and private agencies. That the states themselves have failed to recognize the essential tribal relations of Indian people and the cultural and social standards. Congress, therefore, declares the policy of this nation is to promote the stability and security of Indian tribes and families, providing for assistance to Indian tribes in the operations of their child and family services. One of the biggest reasons that tribal courts in the United States have such a strong jurisdictional footprint is because Congress recognizes, gives resources to their ability to affirm the tribe's own child placement welfare decisions. So the tribes have their own lawyers and social workers and community structures that make decisions about where a kid might go. And then the tribal court, if there's a dispute, can work through the challenges of that dispute. So there's checks and balances. It's not just all the tribal council doing this. There's accountability that's there. And the results have been that in the 1970s, when this piece of legislation was passed, in many states they had the same high rate of Aboriginal peoples being in care that we contemporarily have in Canada. Remember, like 70–80% of the kids in care in some of the provincial jurisdictions are Aboriginal. In British Columbia, 50% of the kids in care are Aboriginal. That used to be the case in Washington State, Montana, Minnesota, Arizona, etc. No longer the case. No longer the case. The rates of kids in care that are Aboriginal are about the rates of their population proportionality. So if there's 6% of the population of Washington State is Indigenous, it's about 6% of those kids that are actually in care. So what's the difference here? Because the provincial legislation has all of these same placement preferences. British Columbia's provincial legislation has the same placement preferences. British Columbia's legislation also recognizes the challenges and failures in the past. Why with the exact same, not exact, but why with the same piece of legislation are the provinces failing and the tribes succeeding? I think there's two reasons. One is that this is resourced by the federal government. Congress, not ever enough. There's always deficiencies, but Congress steps behind the provision of funding. And again, never enough, and you can read horror stories there. Self-government is never utopia, it's never perfect. There's always disasters, including disasters within tribal forum. But that's one reason why this might work, is there's just a focused attention by one jurisdiction to make sure that things are getting better. And then secondly, I think it makes a difference when people closest to the issue are presiding over it, but are doing so in a way that can pare away their own bias and self-interest through the tribal court structure. I actually think it's tribal courts that have made all the difference from moving, say, the kids in care of Minnesota, like 50% down to whatever, 6 or 7%. There's something about that accountability mechanism that's powerful.
Is the act that covers Indians in same as or very different from the Indian Act in Canada?
These acts in the United States are very different from the Indian Act in Canada. In the 1960s, the federal government said we are no longer going to pursue a policy of assimilation, and so there's been over 40 pieces of legislation in the past since 1969 that they actually implement self-determination. The starting point in this legislation is that tribes have inherent sovereignty, here dealing with Indians, and the federal government can support that sovereignty by providing structures and systems and resources to help in that development. So very different legislative framework.
And so does the education cover the general public so that when they have to make decisions about their children, do they know the laws? Are they taught the laws? How does that happen?
So there's much more infrastructure and there's more of a civil service on Indian reserves in the United States that are culturally appropriate. Like not all cases, I don't want to overemphasize this, but by and large. And furthermore, the Bureau of Indian Affairs is run by like 80% Indian people. Again, it's a huge problem with the Bureau still, but its purpose is to facilitate self-government. And so people working in the Bureau or people working in the civil service of the tribe, there's like tribal education acts and tribal college acts that, again, Congress does what they do here, which is occupies the field and allows for First Nations to have the knowledge to be able to pick up the responsibility under these pieces of legislation.
One more question. So then, if like that infrastructure sounds pretty positive, what about healing? You know, making a person whole?
Yes. So within tribal courts, there's often a whole division which is called a healing court or a therapeutic court. There's also language legislation to be able to facilitate language development. Again, I don't want to overemphasize this. There's still lots of problems there, but healing is more of an explicit goal of Congress's role, and they put that into legislation. Right? So then the Congress can be accountable for how they act. In Canada, we have one piece of Indian Act, which is very weak and it's assimilative. And then secondly, when the federal government usually acts in this country, they do so by policy. You can't take the government to court usually to implement the policy, right? They haven't held themselves to accountability like you find with legislative suites of action. So there's something here of a lesson, and again, when I teach this in the United States, I'm as critical of this as I am praising it. But when I step into the Canadian context, I mean, this just looks like a city on a hill compared to what we've got in our own backyard. It's not without criticism, but comparatively, it's only a dream. So we've got this Spallumcheen bylaw. So now we're into the materials, and we're like 55 minutes along. Spallumcheen bylaw here, preamble. The removal of our children by non-ban agencies and the treatment of the children while under the authority of non-ban agencies has too often hurt our children and serves to fracture the strength of our community, thereby contributing to social breakdown and disorder within our reserve. Here's a quote from the materials in that regard. In 1980, out of 500 people being registered in this band, 80 children were in government care. A social worker chartered a bus and apprehended, this is a quote now, 38 children in the 1970s. Spallumcheen became a quiet, dispirited town of adults and elders with at times fewer than 14 children left on the reserve. Drinking and despair intensified rather than dissipated, and it was generally known that once children were taken, they were never returned. So in the 1980s, in response to this, they passed this bylaw to be able to try to get at this fracturing of their community. And the jurisdiction was that the band would have exclusive jurisdiction over any child custody proceeding in involving a Spallumcheen child, notwithstanding the residence of the child. So if the Spallumcheen child was growing up here in Victoria, and there was a question about custody, the band back in the interior would have authority over that matter. Did you have a question? So they would have authority over that matter. They also have a placement preference for the parent, then member of the extended family, yes.
So I was just curious when I was reading this, what it actually took for the band to go about the formal process of taking that power back.
Yes.
Because I was kind of wondering why all the bands wouldn't have done that
Yes.
if it meant taking the authority back.
So all the bands in British Columbia and across Canada want to do this. So how did they do this? It was a mistake. They drafted this, and then you send this along to Indian Affairs, and you have 40 days. If it doesn't get sent back to you in 40 days, it becomes law. Someone didn't catch at Indian Affairs that this was there, and so 40 days are up, it suddenly becomes the law of the band. Every time another community has tried to advance that kind of authority, it's sent back. It's disallowed, because the Minister of Indian Affairs has that authority to disallow band council resolutions. So that's why.
Okay.
So did it have to go right to the minister?
So it doesn't go to the minister, it goes to the delegate of the minister, which is the machinery in the Department of Indian Affairs. And yeah, this just happened to slip through. So, you know, we were talking about occupying the field a moment ago. It's even difficult for one band to occupy the field and have paramountcy, because in this case, what this piece of legislation does, as we know in the case, gives the Spallumcheen bylaw paramountcy over the Provincial Child and Family Services Act.
So what's stopping a ban from, for example, suggesting this is the bylaw and then sending it in 6 days a week for a year until it finally slips through?
They could do that, and they could succeed in maybe getting it slipping through, but you know, I think someone learned their lesson on the other side of this as well, to not allow this to slip through. This is Section 88 in action again, remember? There's just such a antipathy for having Indians exercise control of their own affairs. They want the provincial laws of general application to apply to Indians on the reserve.
We're getting a lot of nice, at least, rhetoric from our new minister.
Mm-hmm.
Do you have any thoughts on whether this sort of thing might be allowed to slip through in the future?
Well, this might not even just be a slip through in the future. You could see, if they're reviewing the legislation to coincide with the United Nations Declaration on the Rights of Indigenous Peoples, the Convention on the Rights of the Child, our broader Section 35(1) analysis. Look at the United States, that's why I spent 50 minutes on this, right? We were teeing up for potentially being in another world, but it's going to take allowing for a First Nations jurisdiction. It's going to take going against this. All provincial laws of general application are always the thing that controls Indian affairs. That's possible. Now, whether or not that will occur, we've had liberal governments in the past, and nothing has ever happened like this. So we might be hopeful in this moment, but you just never know.
Given that the people who are in the positions as minister are younger, do you think that
So this is my own personal opinion. I think that that does make a difference, not just in relationship to age, but their own life experience. You look at both the Minister of Indian Affairs, who's been quite active as an advocate for Indigenous peoples along the lines of the things we talked about over this last hour. Jody Wilson, who's the Minister of Justice, was the BC Regional Chief for the Assembly of First Nations, worked on the Treaty Commission before that, was a prosecutor in the downtown east side with a huge Indigenous population. Was from Vancouver Island here. I remember teaching her when she was at the University of British Columbia and I was a professor there. She certainly went through life thinking about and working through these issues in the way that we are in this place. I don't know that we've ever had a Minister of Justice that's had that kind of opportunity and background before. A lot of hope for her. I think she's a very strong and powerful woman. Now, the politics that surrounds her, I don't know where that's all going to go. So here's this placement preference again, which is similar to the United States Indian Child Welfare Act. It's actually even similar to the provincial legislation, but here the tribe, using U.S. language, First Nations gets to control. Here's the band, Spallumcheen here, east of Kamloops, north and west of Castle Star and Nelson, in that area. The facts are that there was this woman who, Spallumcheen woman, who wasn't registered in the band, gave birth to a child. When she gave birth to that child, she placed it in a voluntary care arrangement with a non-Aboriginal family. But then this woman was Aboriginal, gave birth to the child, was registered as an Indian, and with that registration, Spallumcheen suddenly has jurisdiction over the child, no longer the province. The Spallumcheen band continues the care arrangement, though, that is there with this non-native woman and family. But then things start to break down, and it's not quite clear why they broke down, but there was an abrupt transition, which was regretted by the band, which was disputed and by the woman that had been raising this child for a couple of years, and the Spallumcheen band placed the child with the aunt. Non-native woman that had been raising the child disputed that and said the court should exercise its parents' patriae jurisdiction to return the child back to the first placement, to the woman who is non-native. So the court has to address this question: should it exercise its parents' patriae jurisdiction to take the child back, put it in the non-native person's care? The decision is that the parents' patriae jurisdiction is limited, since legislatures have acted so completely in the field, not only with regard to child welfare, but many areas where that kind of discretion could be exercised by the court. The parents challenging the bylaw argued that this is now what Spallumcheen is called, Splatson. The Splatson bylaw was not complete. That is, in the voluntary care arrangement that this child was under, there was no provisions as to how to deal with a dispute between the Splatson, Child and Family Services, and the woman or the family if the child was going to be removed from their care. So there's this idea that there's a gap in the legislation. It's incomplete because that kind of dispute is not accounted for. There's no process for dealing with it under the ban bylaw. Does not provide for foster parents with status to apply for custody or adoption when a voluntary care agreement is in place. The court says, while the bylaw has its gaps, it is a clear statutory scheme for the care of children. And when the parents gave this, when this care agreement was made, there was an understanding that this person could be removed at any time, this child that they're caring for. And the same gap that the hoped for adopted parents identify in the ban legislation is also the same so-called gap that's there in the provincial legislation. So this woman would be under the same status if the province decided to change a voluntary obligation as voluntary care agreement, as would be the case if the band decided to make this change. And furthermore, the court finds that the child is not in need of protection here. And without this need of protection, there's therefore no excuse for them exercising that parent's patriae jurisdiction. So, in other words, the band bylaw, the governance of the First Nation is left in place. It has paramountcy over the provincial legislation or the court's own jurisdiction cannot interfere with this structure. So this is a deferential standard to the operation of this law. And then you'll see in the materials that this became a matter in the Legislative Assembly, and there was a push by one of the speakers to say all children in British Columbia deserve to have their rights protected under provincial law, and this is no exception. Now this government is debating whether or not they even have jurisdiction to protect this little girl. Will the minister acknowledge her responsibility to protect the rights of baby F under our provincial legislation and act immediately to ensure that the best interests of this child are put first? And we have committed ourselves under the convention, as we have committed ourselves under the Convention of the Rights of the Child. So there's a member of the provincial legislature saying this is contrary to law because all children should be protected under provincial legislation. The answer back by the member for the government is that, but the courts have now recognized that there is a jurisdiction here. They actually didn't say, she didn't say that, but so the courts have recognized, have dealt with this issue. So we do have provincial legislation that tries to put into place many of these same protections that were there in the federal U.S. scheme or the Spallumcheen scheme. You see that applies to Indians construed broadly, including self-identity under Section 1 there. Section 2, the Act should be administered and interpreted so that the cultural identity of Aboriginal children should be preserved. This Section 3 here is the permission to create Aboriginally run delegated agencies to deal with Aboriginal children. That is, Aboriginal people should be involved in the planning and delivery of services to Aboriginal families and their children. And then when best interest is taken into account, you have to take account of the cultural, linguistic, racial heritage of the children. So this is legislation that's in place. Great wording, great structure. Section 3 has led to the negotiation of delegated Aboriginal child welfare agencies. There are 22 of these in British Columbia, 23 First Nations, I guess there's 22 agreements. This doesn't make sense. There's a lot. Right? 23 First Nations agencies, 4 Métis agencies, 3 urban. I don't know why I've got that number before. They're supported by a group called the First Nations Children, Caring for the First Nations Children Society. You can look on the web at the kind of resources that this agency, the society gives to support the Aboriginal agencies. There's an assumption of authority. These agencies go through 6 stages. There's a pre-planning, so say you're a First Nation and you want to set up one of these agencies. There's a pre-planning stage, a planning stage, startup, then you start offering voluntary child protection services, guardian services, and then full delegation. So there's ways for Aboriginal peoples to get involved here. But look at the word delegated. Right? It's always from the provincial government delegating that to you, and then if there's a dispute, the dispute goes back to the province or goes to provincial court, unlike the child welfare law in the United States. 3/4 of First Nations in British Columbia are represented by these agencies. They do have a dispute resolution process. The dispute resolution process includes other alternative dispute resolution mechanisms. In other words, under this, you could have Indigenous law start to be used by these agencies to deal with custody, placement, termination of rights, etc. There's been encouragement by by some advocates working in this field, like Ardith Walkham. There's not been a lot done there yet, though. So this is, on the face of it, good legislation. It's certainly an improvement over not having Aboriginal peoples involved at all. But it still continues to fail. Even though Aboriginal peoples are involved in administering provincial delegation, it still doesn't seem to be the answer to the problem although it's better than them not being involved.
I know that, like, on the ground, they see these delegated agencies as just like an extension of the provincial child and
These are an
family
extension of the provincial authority and of the Provincial
They're
Child
not
and Family
like
Service Act.
an actual Indigenous infrastructure that would legislate and take care of children in Indigenous ways.
No, it's not like the stuff we talked about with the Declaration on the Rights of Indigenous Peoples or the Section 35(1) or the federal response in the United States. This is very much the province doing this and First Nations just getting involved with the province in doing this. And again, let's not turn our nose up at that. That's a huge step. Life is better for some people as a result of this. But there's still a huge lag. And so you have this provincial child and youth representative, which has a mandate to try to hold this provincial system to account. In the wake of deaths and underfunding, there was a representative of Child and Youth Act. In this person, Mary Ellen DePelle-Lafond, is a Cree woman, an independent officer of the legislature that supports, advises, aids families in receiving services from that provincial perspective, monitors, reviews, audits, and conducts research and services, which she's done quite well. With that, there's reports on critical injuries and deaths, and I encourage you, if you're interested in this field, to look at the website. I encourage you to, there's a 1-minute clip here, to listen to her own self-description of what it is that she thinks her authority is. It's a significant role. She regularly ticks off the minister and the agencies and frontline workers as she tries to hold them to account for the way that they operate and not always taking First Nation, and she's for all children, other children's welfare into account. I'm not going to look at the auditor's report here, except to say that it is the case that there's still half of the children in care in BC that are Aboriginal. Leave that aside, because I want to look at this Lester Desjarlais case. So, 2 tragedies when First Nations exercise self-government. Just because people have control to a degree over their own affairs does not mean this is the total answer to the question. Do not think self-government is a panacea. Do not think self-government is utopia. But it's one of the many things that need to be done. It's often one of the most important things to be done, but it can also lead to problems. So Lester Desjarlais, young Indian boy under the care of the Dakota Ojibwe Child and Family Services, he took his life. So there was an inquiry as to what happened. This Ojibwe Dakota Child and Family Services failed to intervene to take action on behalf of Lester when it had knowledge of the severely abusive circumstances in which he was in. He became a pawn where the larger political struggles that were taking place within the agency. The agency did not take sufficient measures to protect him from known sex abusers. They mismanaged and suspiciously lost critical files. And the band councils interfered with this Child and Family Services structure to protect their own political cells and to protect their own relatives, to protect the agency from investigation on their reserves. And the male Indian leaders are not only by and large uninterested in the horrific social problems that are paralyzing their communities, but they are in many cases the problem themselves. And the director of the agency was virtually absent in getting involved in dealing with that politics. So here's the lesson. When you set up any structure on the reserve, education board, economic development, child welfare services, healthcare, you need to find a way to attenuate the band's direct authority and supervision of the day-to-day actions of that agency. Yes, the band needs to have the broader political oversight for it, create the accountability for those agencies, but you cannot have a band counselor going to the education board and saying, we want you to do things this way, comply. Or going to the Child and Welfare Agency, Child and Family Service Agency, and say, comply. Right? You need a strong, diffuse system of authorities, like we used to have through our, and still do have through our clan systems. Band council cannot be the only game in town. The next case also illustrates the same issue.
So just to clarify that, the conflict there is that the band found out that things weren't working well and didn't want outsiders to come in and take a look and see that they weren't working well out of fear for that power being removed from them? Is
That's
that-
part of it.
Okay.
And then when the information was brought to them, they just kept manipulating the information so there wouldn't be further investigation of.
Okay.
Basically, what was happening here is there was, I better not speak further. Someone was covering up for someone else this abuse, and their friends and family on council worked to cover up that abuse. And I know that most people that have any exposure to Indigenous communities recognize this is one of the main problems. And it's an Indian Act problem. Because the Indian Act creates this centralized authority, as weak as it is compared to the federal government or what it could be, does not have a tribal court to hold it to account. Does not have independent agencies that can do their own thing and be another kind of structure in the community that, again, makes decisions without the band always interfering.
I think when I sit and I recognize the issues and have talked about it, I think part of the problem is within the type of control that the band council has. It's so small
Yes.
that they will control anything.
Any little thing they get because
Yeah.
it's so small. Like
And it's pittance.
it's pittance. And so some people say, and you would agree with them, Aboriginal people should not have self-government because look how they're messing it up. If Aboriginal government is the Indian Act, yeah, that is not what should be striven for. That's a word. But if we could get to other kinds of structures where tribal councils could act in accordance with and implement the Declaration, the Convention on the Rights of the Child, Section 35(1) in a way that that federal scheme operates in the United States with checks and balances and different kinds of interactions. But people step forward and say Indians can't do it because they don't see the Indian Act as such a foreign imposition. It just looks natural, and some of our own people think that that's what governance is the way that the Indian Act is. This is a terrible situation, this Jane Doe case. But what was extra problematic about it was not only what happened to this young woman, but then the Child Welfare Agency wanted to seal the records so that no one would hear about their misconduct. I just think that's unconscionable. Fortunately, the court here said you're not going to get away with that. The world is going to know, so that's why I put this in the case book, as challenging as it is to read the facts. To take our eyes of romanticism off here and recognize the complexity, but then I spent the first hour like I did to see that that complexity doesn't have to fall into an Indian Act structure. Right? There's other ways of reorganizing this. But again, even when they're reorganized, won't be a panacea, but hopefully will put us in a position to protect kids. I'll give you the last word.
Take the Indian Act away, go back to the traditional way of working together as clans, have the umbrella of the nation, and have a judicial system that holds people accountable. Because in our way, in the hideaway, we had the checks and balances.
Yes.
And it worked really well. And the government removed the hereditary leaders and put in the elected ones to disrupt that
Yeah.
and to get rid of it.
Thank you. Next class, we'll start out with criminal justice, and you'll see the connections.